This is a list of legal terms relating to patents. A patent is not a right to practice or use the invention, but a territorial right to exclude others from commercially exploiting the invention, granted to an inventor or his successor in rights in exchange to a public disclosure of the invention. A. Abandonment. The reply of an applicant to an office action must be made within a prescribed time limit. If no reply is received within the time period, the application may be considered, depending on the jurisdiction, as abandoned or deemed to be withdrawn, and, therefore, no longer pending. Annuity fee. A fee to be paid to maintain a patent or a patent application in force, also called maintenance fee or renewal fee. Application. An application for a patent, or patent application, is a request by a person or company to the competent authority to grant him a patent. This document usually contains a description of the invention and at least one claim used to define the sought scope of protection. Assignor Estoppel. In United States patent law, an equitable estoppel barring a patent seller from attacking the patent's validity if she is found to have infringed that patent later. Auslegerschrift. In outdated German patent law, the second reading, or publication, of a patent application. Author's certificate. A form of inventor's recognition formerly available in the Soviet Union and a number of socialist countries, also called inventor's certificate. B. Bowler exemption. C. Research exemption. Branching off under German patent law, a procedure consisting in deriving a utility model from a pending patent application, also called derivation. C. Catch and release. The practice of a patent holding company buying a patent, offering a license to its members and then selling or donating the patent after a certain period of time. Chapter 1 in the Patent Cooperation Treaty. Chapter 1 refers to the prosecution procedure when no demand under Article 31 PCT is made. The states selected under Chapter 1 by the applicant are called designated states. Chapter 2 in the PCT. Chapter 2 refers to the prosecution procedure when a demand under Article 31 PCT is made. An international preliminary examination is conducted in this case. Claim. A noun phrase defining the extent of the protection conferred by a patent, or the extent of protection sought in a patent application. Clearance. Search and opinion. A search done on issued patents or on pending patent applications to determine if a product or process infringes any of the claims of the issued patents or pending patent applications. These searches and opinions are also called freedom to operate searches and opinions. See patent infringement. Common general knowledge. A legal concept used notably when assessing whether an invention involves an inventive step and whether the disclosure of the invention is sufficiently clear and complete for a skilled person in the art to be able to carry out the invention. The common general knowledge is the common knowledge in the field to which the invention relates. The information must be generally known and generally regarded as a good basis for further action by the bulk of those engaged in that art before it becomes part of their common stock of knowledge relating to the art, and so part of the common general knowledge regarding the inventive step assessment. If information is part of the common general knowledge, then it forms part of the stock of knowledge which will inform and guide the skilled person's approach to the problem from the outset. It may, for example, affect the steps it will be obvious for him to take, including the nature and extent of any literature search. Under European practice, the common general knowledge of the person skilled in the art is, as a general rule, established on the basis of encyclopedias, textbooks and the like. Exceptionally, however, common general knowledge may also be established on the basis of the content of patent specifications, and in particular when a series of patent specifications provides a consistent picture that a particular technical procedure was generally known and belonged to the common general knowledge in the art at the relevant date. Compulsory license. Using compulsory licenses, a government may force a patent proprietor to grant use to the state or others. Usually, the holder does receive some royalties, either set by law or determined through some form of arbitration. Continuing application in United States law, an active patent application, prior to final action, may give rise to additional applications for additional claims carrying the priority date of the original application. With the move to published applications, this has become a common way of producing submarine patents. Contribution approach under European patent practice, a legal approach, now abandoned by the European Patent Office. For assessing whether an invention was patentable, the approach consisted in establishing whether the contribution to the art made by the invention was only in a field excluded from patentability by Article 52 and 3 EPCE, and, if so, the application could be refused. The EPO now applies the sometimes named any hardware or any technical means approach, notably formulated in EPO Board of Appeal decisions T258/03 and T424/03. Contributory infringement, a form of indirect infringement. D. Declaration of non-infringement, a declaration obtained from a court that one's actions do not infringe a particular patent. An action for a declaration of non-infringement may be brought before a court as a preventive measure prior to being sued by a patent proprietor. For example, if an infringement suit is believed to be imminent. Defensive patenting, a practice consisting in obtaining patents to stake one's claim to an area of technology in hopes of preventing other companies from suing them. See also defensive patent aggregation. Defensive publication, a publication intended to prevent the grant of a patent to a competitor by placing information in the public domain. Defensive termination, an implicit cross-license where the licensor can terminate a patent license if the licensee turns around and sues the licensor for infringing a patent. Demand letter, a letter sent to a company seeking royalties and threatening legal action for patent infringement, also called the threat letter. Demand under Chapter 2, a request to subject an international application to an international preliminary examination under Chapter 2 of the Patent Cooperation Treaty. Dependent claim, a claim comprising all the features of another claim. Design around the act of developing an alternative apparatus or method that does not infringe upon an issued patent. Also used as a noun. Designated office under the Patent Cooperation Treaty. A national patent office of or acting for a state designated by the applicant under Chapter 1 of the PCT. See also Chapter 1 above. Disclaimer, in a claim, words identifying subject matter that is not claimed or, by extension, an amendment consisting in limiting a claim by introducing therein a negative technical feature. Divisional patent application, a type of patent application which contains matter from a previously filed application. Also referred to simply as divisional application. Doctrine of Equivalents, a legal rule that allows a court to hold a party liable for patent infringement even though the infringing device or process does not fall within the literal scope of a patent claim, but nevertheless is equivalent to the claimed invention. Double patenting, the protection of one single invention by two patents usually owned by the same proprietor. Druck exemplar at the European Patent Office, the application documents serving as the basis for the publication of the granted patent. Elected office under the Patent Cooperation Treaty. A national patent office of or acting for a state elected by the applicant under Chapter 2 of the PCT. See also Chapter 2 above. Embodiment, in a patent or patent application, a specific combination of features or a specific mode of carrying out the invention. By contrast to a more abstract definition of features which can be carried out in more than one way. Essential patent, a patent claiming an invention that is required to implement a given industry standard. The concept of national exhaustion, which is recognized in most countries around the world, is distinguished from the concept of regional or international exhaustion, which is recognized in some countries but not in others. Examination support document. According to USPTO patent rules, the examination support document is a document submitted by an applicant that lists prior art and identifies how the prior art applies to the claims in a pending patent application. Fair, reasonable, and non-discriminatory licensing. A type of licensing typically used during standardization processes, also abbreviated FRAND. Field of use limitation. A provision in a patent license that limits the scope of what the patent owner authorizes a manufacturing licensee to do in relation to the patent, by specifying a defined field of permissible operation or specifying fields from which the licensee is excluded. File wrapper. The special folder type holding a U.S. patent application. The file wrapper was a large 3-section binder that interlineated to close into one large wrapper. These paper file wrappers were fully digitized as of June 3, 2003 and are now called image file wrappers. Filing date. The filing date of a patent application is the date the patent application was filed in one or more patent offices, i.e., the date on which that application is legally accepted at the patent office. That date is typically the date on which the documents are deposited at the office, but may be later if there are defects in the documents. See also priority right. In the United States, if a patent application is mailed to the United States Patent and Trademark Office by express mail, post office to addressee, then the date the application was deposited in the post office is the filing date. First sale doctrine. See exhaustion of rights. First to file. A legal concept in which the right to a patent for an invention is determined by the first person to file for a patent to protect that invention. Cf. First to invent. First to invent. A legal concept in which the right to a patent for an invention is determined by the first person to make that invention. Cf. First to file. Flash of genius. A test for patentability formerly used by the United States federal courts. Freedom to operate. A freedom to operate search is a search aimed at establishing whether a product or process is covered by patent rights, including patent and patent applications. If it does, commercially exploiting the product or process may lead to patent infringement. Freedom to operate analyses and opinions are aimed at determining the risk of patent infringement in that respect. These searches and opinions are also called clearance searches and opinions. Further medical use. See second medical use. G. Gebrauchsmuster. A utility model in German and Austrian laws. I. Independent claim. A claim that does not comprise the features of any other claim. Indirect infringement. When a patent is infringed by some party other than the one actually directly engaged in the infringement of the invention, but the original party is the cause of the infringement. For instance, when a third party supplies a product which is intended to be used, or can only be reasonably used or worked upon to make the device claimed in a patent. In some jurisdictions, forms of indirect infringements include contributory infringement and induced infringement. Induced infringement. A form of indirect infringement. Industrial applicability. A requirement of many patent systems, requiring that an invention be capable of industrial applicability in order for a patent to be granted for that invention. Information disclosure statement. In United States patent law, a submission of relevant background art or information to the United States Patent and Trademark Office by an applicant for a patent during patent prosecution. Innovation patent. A type of patent in some countries used for inventions that have a short commercial life or that offers a comparatively small advance over existing technology. It often has a shorter term of protection, for example 8 years instead of 20 in Australia. See also utility model and petty patent. Interference proceeding. Under U.S. patent law, proceedings to decide who is entitled to the grant of a patent for an invention International application. A patent application filed under the Patent Cooperation Treaty, also called PCT application. International preliminary examination report. An examination report prepared under the Patent Cooperation Treaty. Invalidity opinion. An invalidity opinion, also called validity opinion, is a legal opinion provided by an attorney on how a court might rule on the validity of an issued patent. Invalidity opinions are often sought prior to patent litigation. See patent infringement. Invention disclosure. A confidential document written by a scientist or engineer for use by a company's patent department, or by an external patent attorney, to determine whether patent protection should be sought for the described invention. Invention promotion firm. A firm providing services to inventors to help them develop or market their inventions. Inventive step. A patentability requirement according to which an invention should be sufficiently inventive, i.e., non-obvious, in order to be patented. Inventor. The actual deviser of an invention that is the subject of a patent. The inventor's employer is not the inventor. More than one inventor can be named on a patent. Inventor's certificate. See author's certificate. Kokai. A published, unexamined Japanese patent application. Kokoku. An examined and approved Japanese patent application. Large entity in United States patent law, one of the available applicants' status, along with the small entity status and the micro-entity status. Letters patent. An old term for a patent, sometimes used in reference to a bound formal copy of a patent provided by the USPTO to the inventor upon a patent's issue. License. A contract wherein a party grants to another party the authorization to use an invention which is subject to a patent, generally in exchange of a financial compensation, the royalties. Machine or transformation test. A criterion in United States patent law, according to which a claimed process is patent eligible if it is tied to a particular machine or apparatus, or it transforms a particular article into a different state or thing. See also. In Rebilski. Maintenance fee. A fee to be paid to maintain a patent or a patent application in force, also called annuity fee or renewal fee. Markman hearing. A pre-trial hearing in the United States court system during which a judge hears testimony from both parties on the appropriate meanings of the relevant keywords used in the claims of a patent, the infringement of which is alleged by the plaintiff. McKesson reference in United States patent law. An information disclosure statement reference to a communication with a patenting authority in a related patent application, based on the McKesson v. Bridge medical decision where inequitable conduct was found where the applicant failed to notify the USPTO of such references. See also inequitable conduct. Marlowe reference in United States patent law, and its reference to a court document pertaining to a litigation involving an application or a related patent application, based on the Marlowe Industries, Inc. v. Igloo Products Corp. decision where the court found that the applicant had a duty to notify the USPTO of such references. See also inequitable conduct. Method in United States patent law, a patent may notably claim a process or method. The claim gives right to exclude performance of the process or method, regardless of the equipment or technology used to do so. Microentity status. See small entity status below. National phase. The prosecution phase wherein an international application filed under the Patent Cooperation Treaty becomes subject to examination at a national level. In the United States, the term national stage is used instead. See 35 U.S.C. 371. Non-obviousness. A patentability requirement according to which an invention should not be obvious to a person having ordinary skill in the art in order to be patented. Non-patent literature. Any technical document that is neither a patent nor a patent application and that is submitted by a party, such as an applicant, an opponent, or a third party, or cited by an examiner during patent prosecution. The non-patent literature includes especially scientific papers used as prior art to show that an invention claimed in a patent or patent application was known or obvious before the filing of the application. Also abbreviated, NPL. Non-Provisional Patent Application, a United States patent application that is not a provisional application. The term arose in 1995 to distinguish what were at the time normal patent applications from the newly established provisional applications. A complete non-provisional application differs from a provisional in that a non-provisional must contain at least one claim and is to be examined. A non-provisional application may also claim priority to a prior filed application, which is not permitted with provisional applications. Novelty, a patentability requirement according to which an invention is not patentable if it was already known before the date of filing. Nullity, action, lawsuit initiated by a party requesting a patent to be declared invalid, i.e., to be revoked. Also called revocation action. O. Office action, a formal report from a patent office examiner to an inventor or attorney detailing which claims in a patent application were allowed for later issue in a patent and which claims were rejected. The examiner gives reasons for allowance or rejection. On sale, a concept of U.S. law in which the grant of a patent is prevented if the invention that is the subject of the patent application was on sale more than 1 year prior to the priority date. Opposition proceeding, proceedings in which a third party opposes the grant of a patent in an attempt to prevent that grant, or have the patent revoked. Opposition proceedings may be pre- or post-grant.